The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Mr. Gross, you may proceed.
Thank you, Chief Justice Gregory, and may it please the court. The lay witness evidence presented at the PCR hearing establishes ineffective assistance of counsel under both prongs of Strickland. Regarding the performance prong of Strickland, trial counsel failed to interview and call available lay witnesses that would have provided detailed and specific evidence about Mikhail Mahdi's childhood. Trial counsel did not interview the majority of the lay witnesses that testified at the PCR hearing, and the ones they did interview, they did not interview competently. Thus, the PCR judge and the district court unreasonably found and concluded that trial counsel conducted a reasonable mitigation investigation. Regarding the prejudice prong, the PCR judge and the district court unreasonably found and concluded that the lay witness testimony was cumulative to Marjorie Hammock's 24-page sentencing hearing testimony. Of that 24 pages, 8 pages, or 1/3 of the testimony, was devoted to explaining her expert qualifications and the methods that she used. The lay witness testimony presented at the PCR hearing would have precluded and changed the trial judge's findings of fact regarding Mikhail Mahdi's character that are set forth in the sentencing order. Significantly, the sentencing order is void and omits any information or factual findings regarding Mikhail Mahdi's childhood before the age of 15. PCR evidence detailed detailed the violence that Mikhail Mahdi inflicted on Mikhail's mother, Vera, that he and his brother were forced to watch, resulted in Vera having to flee the household in order to protect her safety. When she wanted to take Mikhail and his brother with her, Sharif threatened to kill both of them. And then there was the lies that Sharif told. Despite Vera running to flee Sharif's violence, Sharif told Mikhail and his brother that she didn't love them. He also lied and told them that she was dead. The evidence presented at the PCR hearing through the lay witnesses also established Sharif Mahdi's utter lack of parenting skills and inability to provide for Mikhail's basic needs, leading Mikhail to have to fend for himself on some occasions. The lay testimony, particularly the teachers, presented and charted the depths of the educational neglect that Sharif had towards Mikhail. Early in Mikhail's life, there was large gaps in his attendance. When Mikhail moved to live with his aunt and uncle in Baltimore, he wasn't able to read, despite having the intellect to be able to do so at that age. The lay testimony, particularly the teachers, also uncovered the depth of Mikhail's childhood depression. When he was in the 2nd grade, he said, "Why doesn't somebody just shoot me? If I had a gun, I would shoot myself." And then there was a complete failure of the family to provide Mikhail with the psychiatric treatment that was recommended by the school officials. Between the 2nd and 3rd grade, Mikhail learned about the lie that his father Sharif had told him and learned that his mother was in fact alive. But the reunification went horribly wrong. Mikhail watched his father beat his mother, and she had to run into the woods. And then he witnessed his father beat his grandmother, Nancy Burwell, by tying her to a tree and whipping her bare legs. That was what Mikhail witnessed between the 2nd and the 3rd grade. When he returned to the 3rd grade, his teacher said he was withdrawn, which is not surprising after the traumatic summer that he just endured. Myra Harris, the teacher, watched Mikhail to begin to thrive in her classroom when he had the structure that she was able to provide, and also when he was away from the toxic environment provided by Sharif, because at this point, Mikhail was still living in Baltimore. But even Baltimore wasn't a happy place and a successful place for Mikhail. We already talked about him not getting the psychiatric care that was recommended following the second grade. There's also the 10 to 15 minute beating that his Aunt LaWanda inflicted upon him that led Mikhail to ask for the police officer to give him his gun so that Mikhail could shoot himself. During the subsequent...
Counsel, let me ask you, is there anything that you say Ms. Hammock, the social worker, testified to or included in her written reports that was inaccurate?
Well, it depends upon what you mean by inaccurate. I mean, the trial judge in his sentencing order was allowed to conclude that Mikhail...
Well, what I mean, is there anything that she testified to or put in her written reports that was not factually correct?
Well, her written report painted a picture of a child who had supportive parents and didn't witness violence, didn't experience violence in his lifetime. Her report painted a picture that allowed the trial judge to find that Mikhail was responsible for the standoff, the 9-hour standoff, that when Sheriff Woodley was finally interviewed and asked the question, testified that it was, Sharif that was the architect of that standoff. And so the question is whether or not Marjorie Hammock painted an accurate picture for the jurors, for the trial judge in sentencing. That report is very conclusory, very summary. Well, it's not even a report, it's just 15 pages of testimony and 2 pages of an exhibit that provided none of this detailed and specific information about Mikhail Mahdi's childhood. And significantly, the judge's findings in sentencing would have been different if this evidence had been presented. The judge could not have found, as he did, about Mikhail's role in the standoff because of what Sheriff Woodley testified to. The particularly harsh, extremely harsh finding that the trial judge made, that he could not find any signs of humanity in Mikhail Mahdi, is refuted by the testimony of the teachers. And I think of the 5th grade teacher who recognized not only that Mikhail was withdrawn, but that he had potential. She had to have Mikhail sit next to him so that he could do his schoolwork and he could draw. And she witnessed the sadness, the very deep sadness and the depression. But yet she said he had, at that point in his life, the ability to succeed and even do well in the world. But she also witnessed firsthand the brunt of Sharif and how he thwarted and prevented her efforts as a special education teacher to bring Mikhail into a thriving environment. Mikhail's father, Sharif, went to the first counseling session and got disruptive and was angry and blamed the psychiatrist or the psychologist for writing a negative report. And this was evidence glimpse into the anger and the hatred and the racial, animosity that Mikhail's father was drilling into him. This ultimately led to Mikhail or Sharif pulling Mikhail out of school and suffocating and choking the life out of his humanity with the supposed homeschooling. I have nothing against homeschooling, but this wasn't homeschooling. This was Mikhail's father, Sharif, going on rants about politics and religion and his racial hatred for white people. It involved, Mikhail's father teaching Mikhail and Sharif violence and survival skills and taught them how to use a knife to stab people and guns to kill people. If this evidence had been presented to Judge Newman would not have been able to make that finding in his sentencing order that there was nothing about Mikhail's life and childhood that explained what happened in the crimes.
And so the answer to Judge Agee's question is yes. There are things that are inaccurate in the program, and that's what you explained now, correct?
That's absolutely correct, Chief Judge Gregory.
And also, I guess your point is that the reason why the judge, understandably so, could say that he saw no humanity because the only thing was left with was the horrible crimes he committed that he was sentenced for. So he had nothing left to judge about the boy inside of the man or the child who was never developed.
I'm sorry.
Is that right?
That's absolutely right, Judge Gregory. And it goes back to the point that I made earlier that the judge's sentencing order begins at age 14 when Mikhail's incarcerations in juvenile institutions begin. It begins after Mikhail has gone through all of this childhood trauma, witnessing the violence, experiencing the violence himself, being yanked out of school and being indoctrinated into this type of, hatred and militant kind of lifestyle. I mean, this is a child who never had a chance from the day he was born. And by the time he was 14 and in juvenile institutions, he was already a severely broken person. And there is a direct line from this violence and neglect perpetrated by Sharif and Mahdi's early childhood that runs to him going to the institutions. And then when he comes out of the institutions, totally lacking the skills to survive in society. And it was unfortunately, sadly, tragically, these skills that were taught by his father about survival and militarism and
Mr.
violence
Gross,
and killing.
Can I ask just a framework question? You've compared the lay witnesses to Ms. Hammock's 15 pages of testimony. And I'm just asking sort of more generally, don't we have to compare because it's a fair to investigate claim, not a fair to present claim.
Well,
right?
it's both.
Right.
You can't present it if you don't investigate.
But all right, let me finish and then you can answer it. You can tell me my premise is wrong, but let me finish the question first. All right. So you compared to Ms. Hammock, but shouldn't we compare the new evidence, what you described as this new evidence from the lay witnesses against all the information that was known, from the mitigation investigator, from the psychiatrist, the social work, all of the private investigator, all of that known information, not just what was presented in Ms. Hammock's testimony. Don't we have to compare it to whether it's repetitive of the information that they did develop, not just what they chose to present?
Well, I think there's several parts to your question. And, one is it can be ineffective assistance of counsel alone to have the information and not have a strategic decision not to present it.
So that's a good point. Where do I look in the habeas petition to find that claim?
Well, the claim is that they failed to investigate and present evidence for mitigation, and encompassed in all of that it's really the state, the government, that has to try to excuse the failure for a strategic reason.
No, because so this is important to me, and I think you've got an argument either way. I just want to understand the framework, right? Because you're saying we're comparing the 7 to Ms. Hammock, right? And you say, well, yes, there is this other information that was not presented. Miss, I think it's Miss Munn. I may have her name wrong. Got school records, talked to school officials, did this, background mitigation investigation. right, and got this information. Not all of that was presented to the trial court, but the lawyers had it.
Well, and the lawyers didn't even present it all to Ms. Hammock, because her testimony talks about reading summaries of some of it, but the testimony is that the teachers
I understand that, but what I'm trying to understand is, don't we have to look at whether these 7 new witnesses that you've identified, whether they are cumulative of the information that had been developed in total, not just what was presented, but what all of the information that Ms. Munn actually had, because that's the scope of the investigation that was done, right? And if it's a fair to investigate claim, we have to compare the new information against what was investigated. No? Help me understand why I'm wrong about that.
Well, they didn't interview. I see my time's up. Can I?
You may answer, yes.
Yeah, there's no evidence in the record that they interviewed the teachers, and in fact, the evidence in the record is that they didn't interview the teachers. The evidence in the record is that they didn't interview Sheriff Woodley,
Right, they did interview school officials, and they did obtain school records.
Well, but
yet they didn't interview these teachers. I understand that, but what I'm saying is they did get. At least the record seems to suggest that they interviewed school officials and obtained school records. Ms. Munn.
Right. Any competent mitigation investigation involves going out and looking for as many teachers as you can find that knew the person when he was as a child, and there was no effort to interview these teachers and learn the powerful mitigation stories that they were able to talk about a child who was still, full of humanity and hope and potential in life. And this is not cumulative to either the testimony or the initial investigation.
And partly in response to Judge Richardson's question, it's also clearly a failure to investigate. You also have to show also that what was there to investigate and what impact it would be. And so I think your argument that is coming and parcel with the whole idea of what the gravity of this unbelievable testimony someone would leave to an investigator to, 20-page or so. It's just so much things developed. For example, they had to investigate. There's a body of work about children who are children warriors in countries where 7 and 8-year-old kids are armed and in conflict, and the incredible trauma involved in trying to repopulate those children after the hostilities have. It's just unbelievable. In a death case, you pled guilty to a judge. The whole thing is to explain the whole profile of the person. So it's hard to separate. I understand Judge Richardson's question, but the whole part and parcel is you can't just put a dry report in it. You got incredible trauma. This kid at 4th grade snatched from school, couldn't read until he was 8, and then he started making progress. That's what the teachers were shown that were interviewed. It's an incredible story meaning in terms of the journey, not tale, but a story of a child who didn't have a chance to be a child. Now he stands condemned as the man, and what you're left with, what happens? A person left in the dark will sin. Who's responsible? The one who sins or the one who creates the darkness? He presents nothing in terms of the darkness at all, just the sin. And to give the judge a full range, that's what this case is about. But go ahead. I'll let you go ahead. You're a little over your time, but I think that you want to conclude with.
Judge Gregory, I think that's absolutely right. And, as the Supreme Court has said in context of juvenile cases, the child has no choice and no ability to remove them from the situation that the parents and the family create for them. And this just is tragic. And you make a good point that, the judge didn't have any information to make different findings that he did. And because that information that undermines those findings exist, the PCR court both was unreasonable in its interpretation of both the facts and the law. And this is why Mikhail Mahdi should have a new sentencing hearing.
All right, thank you. Ms. Brown?
Thank you, Your Honor. May it please the court. I just want to pick up on the conversation that we're having this morning, because what stands out to me is we're missing a step. We're talking about trial, but we're not talking about PCR. We're talking about trial investigation slightly, mostly presentation, but not about PCR investigation and presentation. And I think we need to back up here, because this is not just another collateral action. This is not an opportunity to go in a different direction. Habeas is supposed to address extreme malfunctions in the system. And we're here today because of choices. The choice that Mr. Mahdi made to be sentenced before Judge Newman, the choices that PCR counsel made based on a very intense investigation, and what they decided not to properly exhaust, not to take up to the state Supreme Court in the PCR appeal. There are a lot of choices here that inform this particular conversation, and we're talking this morning about what could have been done differently in presentation. But what could have been done differently, or a few witnesses here or there that are different, does not make trial counsel unreasonable, either in investigation or presentation. And it does not, if something could fit under Martinez, does not make PCR counsel ineffective. I think going back just a little bit and looking at the investigation itself puts things in a bit of context. For trial, the mitigation investigator shared at post-conviction relief that she'd put in over 170 hours investigating, anticipated 75 hours more. She traveled to Virginia. She traveled to Pennsylvania. She traveled to Baltimore. She interviewed family. She spoke with the North Carolina team, because as you'll recall, Mr. Mahdi was on a crime spree down the coast and killed a store clerk in North Carolina before killing Captain Myers in South Carolina. And the attorneys in post-conviction relief also said that they had traveled to North Carolina. They had spoken to the defense team up there. In fact, they had gotten a continuance to be better able to go over what the North Carolina team had, in addition to all of these hours and hours and interviews that their mitigation investigator had. Now, on top of that, even though they were trying, they talk about the accomplishments of other family members. Now, what that would have done, as was explained in post-conviction relief, other family members who had gone to Ivy League schools. And let's keep in mind, Mr. Mahdi was testing at over 100 IQ. I think the last test was 118 IQ. He's competent. And there was no expression for this murder other than to take a car, to take weapons. So when we talk about trying to tie all of this investigation to the context of the crime, what we see in the end result is that by the age of 21, Mr. Mahdi had committed multiple murders, and his motive, express motive, was money.
Ms. Brown, I mean, you can argue the case the way you want, but I guess we are here in terms of answering the court's questions. But you make a great argument about whether or not there was evidence that may have justified the sentence of death and that he did something horrible. The question here is whether or not there are things that were left out that the court needed and should have been, competent counsel would have had before the court. Certainly, I don't think you don't have to convince anybody that the crimes were horrible, that he did horrible things, clearly. The question is, and I think the judge put it quite clearly, And what you talked about is the other members doing well. Oh my goodness, a good lawyer, a trial lawyer, you take that punctuates the trauma and the difference of what could have been. That he was not born in terms of God-given ability, but man's intervention and the horrible beatings that he had. That's a question. Yeah, you can spin it, and you would as a prosecutor, but that's what defense lawyers do, give it a different framework. So everything you're saying, I mean, that's really not is of no moment. You don't have to convince anybody what he did was horrible. It's horrible, absolutely horrible.
Well, Your Honor,
the question is, tell me, I mean, in terms of trying a case, I mean, I've tried a lot of criminal defense cases, and I mean, have this kind of record, you would leave it to somebody else and not these teachers to look at, or whether or not you talk to the teachers. I mean, you talk about she spends so many hours, so what? Hours alone does not translate into truth, no effectiveness, a lot alone. But you can go ahead and argue in one, but I just don't see how that's relevant to what before you skip the PCR. Well, that maybe a lot of those things I think excuse default, and the Martinez claim too, a lot of aspects of it. But it really does start with what was just totally bereft.
Well, Your Honor, I would respectfully disagree, because what we're talking about is the character of the man. We can't just focus on what we believe would be sympathetic. We have to show.
Yes, we do. We do. At this point, we do. Because I agree with you, there's plenty of evidence there that would justify the sentence, perhaps, that he received. Clearly, we're not ignoring that. But the point is, it has to be a balance. The law requires it. That's why you have the Sixth Amendment right to counsel. My goodness, he pled guilty, I mean, to the judge. I mean, so the other side of the thing is what do you do to explain the person? You say we only have a man to judge. That is the narrow thing that was left to the court. But believe me, things that happen in your childhood form the basis. And I think any psychologist will tell you that. Anyway, in terms of trauma and childhood, you just don't wake up and go from depression, cheer up. And that trauma, it stays with you. And that's who was before the court, but the court never had a chance. And the court said it so well. I don't see anything that referenced humanity. And with this record, well, how this case was defended, I can understand that. So, I mean, so again, I just don't see you addressing the question here before, and that is, what if you don't put anything up there, yeah, that's all you have left. But that was available to investigate, to talk to these teachers. For example, you snatched the boy out of school. Did you investigate whether or not he made, when you homeschool someone, it's not just homeschooling somebody, you have to make reports. It's work. It's hard in school. Did you investigate whether or not they're in the records? The only thing you show is that those kind of things, that's important. Don't you agree that's important, counsel? I know you represent the state, but justice requires something higher than just to hear today. Don't you agree that that's would be important if you had a client like that in terms of that kind of history?
I agree that justice requires balance, Your Honor. And that means taking the good and the bad.
Where's the balance on the other side? You're just going totally on. So you think that, are you saying that, is your argument this, that even if the judge knew everything about his childhood, the abuses and all those things, you saying that there's just no way that could have made a difference? Is that what you're saying? That's your argument?
I don't think it's a reasonable probability it would have made a difference based on the fact that he was given evidence of the trauma that Ms. Hammock testified. But again, we're missing that step for the post-conviction relief investigation. And I would like to point the court particularly to Dr. Cooper Luter, who testified as the clinical social worker in the post-conviction relief action. And he incorporated even more themes into his particular presentation. For instance, Joint Appendix 2389 he testifies that he goes into focus in a multi-generational legacy of grief, trauma, resilience, risk. These are the factors Your Honor had mentioned. And he goes into that. He's investigated, he's synthesized the materials, and he's presenting that. And in that report that he issued for the PCR, and this is Joint Appendix 2955, he goes into, quote, bitter resentments about unfair issues of race. At 2956, he notes that Mr. Mahdi was lectured religiously and passionately about the unfairness of white people. 2958, he points out cultural and racial relations. And in his own testimony in post-conviction relief, he looked at the story of Mahdi's life and influences. So all of this was laid bare. And what we found is that there was a lot of bad coming in with a little bit of the good. Now, does that mean you can't present the good? Obviously not. There was trauma presented in the trial itself. And keep in mind, not to a jury.
Counsel,
Yes.
can I ask maybe a factual question? I was talking with your colleague a minute ago about Miss Munn, and I believe you referenced her discussions with school officials and school records. Were there others in the investigation, the psychologist, psychiatrist, the social worker, whoever it was during the trial investigation, not the PCR, who also looked at school records or talked to school officials? Or was that primarily Miss Munn? It's just a factual question. It's a big record. I've tried to get through it, but.
I believe that the defense team worked in tandem. So if those records were obtained, they were also given to other defense team members. And that would have included Ms. Hammock. That would have included the two psychiatrists, psychologists that they had for the trial as well, that they did not use because there was nothing there that was helpful.
Do you remember, this is not a memory test, but which were the two that they used at trial? Which are the two psychiatrists, psychologists that were at trial?
They didn't use them at trial.
No, but that were investigated at trial.
I understand. That was Dr. McKee and I believe Dr. Martin. I believe those were the two. And they just did not have something that counsel thought would be beneficial to present. And what they came to the conclusion of was antisocial personality disorder, which goes back to the character of the man. That's not helpful before either a judge or jury. So they were not presented.
Counsel, if I have a kind of a related factual question. There was a fair amount of evidence, and I simply don't remember whether this was at trial, PCR, or both, about the interviews with Mr. Mahdi's family members, which apparently were fairly extensive. And if I'm recalling either the testimony of trial counsel, psychiatrists, psychologists, there was a conclusion from those interviews that the aggravating evidence that those family members would have brought in to the proceeding far outweighed any mitigating effect. Is that accurate, and at what level was that decision made?
Yes, sir, that is accurate. And the decision not to call some of the family members was made for sentencing. And at that time, there were certain family members who did not cooperate. And that testimony came out at the PCR at 2837 and 2894 to 95. And also some of the individuals who did testify at PCR in support that they would have come down were actually those people that gave information that counsel did not want to use. For instance, one uncle that Mr. Mahdi went to live with actually termed Mr. Mahdi a demon. And that he did not want that kind of information in there, and he expressed he didn't want to come down. That changed. And that's not unusual in these cases. For time to pass and family members change their minds of what they want to say or how they want to say it. And sometimes it's a bit of revisionist history in there. But that isn't sometimes just the effect of time. But that doesn't mean that it affects the reasonableness of counsel. Counsel made the decision based on the information that they had. And it's a reasonable strategic decision not to go in that direction when people are not cooperating.
Counsel, what about the rejection of the request for funding for the race-based trauma expert?
Yes, sir. Abusive discretion standard and the abusive discretion argument that Mr. Motti puts forward is that there was an incorrect legal structure used, and he's relying on a yes-des. And one of the biggest problems he has with that argument, Your Honor, is that a yes-des did not change the statute. The statute, 3599, still is reasonably necessary services. And that's what one has to find. And that's what the district court relied on. That's in the district court order in the joint appendix at 3738.
You mean a court's decision on what that statutory meaning should be applied has nothing to do with the statute now after that case? Is that what you just said? Is that what you just said?
It did not change the statute, Your Honor. It's still reasonable.
It doesn't have to change the statute. It tells about it's a jurisprudential opining on how it should be read in terms of as a standard. It's not an absolute necessity. It certainly did change it in terms of how our court has to look at that. We have it's certainly does. You know, it doesn't change the statute's words, but that's what we do. We interpret statutes, right? And the court said that it was too harsh. It was too rigid in death cases. Am I wrong about that? It seemed like he was using the right standard.
It's not quite that clear, Your Honor, because there was a test that caused a court to look at whether something was substantial. And the court and the Supreme Court looked at that and said, there may be a bit of a difference. It's arguably a bit higher to say substantially needed over reasonably necessary, but that's not the tipping point. The tipping point was, and the court was very clear about this, that you can't say because it's procedurally defaulted, that can't be reasonably necessary to investigate another line of information. That was the tipping point. That was not done here. The claim was not prejudged, and there was no consideration of the procedural default at that point. This was merely investigation. And a yes-days can't apply because he was given money twice. This is the third request that was denied, Your Honor, for the same vein, for the same type of mitigation evidence. And what was being requested was basically a person to create another theme for the presentation of the information that was already obtained. And that is to—
Counsel, you come here and you argue like, you know both sides of the case well. You know your case, you know the defense case. You're telling us now you know exactly what an expert would do. I mean, my goodness, having the way you argue the case, that all we have to do is just listen to you and then just decide the case based on that. Because you tell everything now that, well, that would have only just, but that's what the whole idea is. The man is on trial for his life. The state wants to kill him. And you're talking about funding for a very important part of this person's childhood. It's childhood. And there are many cases that talk about children are different. And you can't expect a child to go through this and come up with a different type of person as a man without giving a full consideration. But everything that comes up, you just flip it and say, well, it's just the same type of thing. It wouldn't be done. How do you know that? You don't know that. I don't know that. That's why the question is, why wasn't given a chance of funding it? I know you're a very smart lawyer, but I don't think that you know everything about what an expert might find when they look at the records. I certainly don't know. And a person's life is on the balance here. It's not just a matter just to flippantly say it wouldn't have made it a difference. The courts seemed like they were bereft of anything. You talk about, my goodness, in a case where nobody in their family was put on. No one. I mean, my goodness, you said, my goodness, is that no one cares whether or not this person lives or dies? And everything a person says to you in terms of the family member, you might start with, and that's what good lawyers do. You hear everybody out what they say, and then somehow you try to get to the point where you can find some distilled evidence that's important. And so we don't know. I mean, but I just thought it interesting how you just sort of casually said, well, it doesn't make any difference, the funding. But is that the standard? That's not the standard. It doesn't have to show they'll be prevailing. And that's important. That will make the case stronger. You come here and have these incredible, and the courts have said that, and death is different. It's different. But go ahead. You know, your time is up. But if you want to make some concluding matter, close, you certainly may.
Thank you, Your Honor. I appreciate that. I think that courts are asked many times to consider whether something is going to meet a certain standard. And while none of us may know 100% on what a juror, or a judge may find important, we do know that there is structure to the judicial system. And we do know that habeas is not just a forum to create another thing. And Your Honor, that's what I rely on. The state of South Carolina allowed Mr. Motti funding and well-qualified post-conviction relief counsel, people who had experience, over 30 cases for one lawyer, 15 capital cases for another, investigative tools, money, time, presentation. That's, Your Honor, why we can say the funding is duplicative at this time, even after it was given in large part by the district court. But I thank Your Honor for allowing me the time to explain that. And unless there are any other questions, I'll conclude.
Thank you so much, Ms. Brown.
Thank you.
Mr. Gross, you have some time reserved.
Thank you, Chief Judge Gregory. The government talked about claims, PCR claims that were not presented to the state court, Supreme Court. And Chief Judge, you mentioned Martinez, but I want to note for the record that every single factual account that I gave in my first argument and every story that I told in the first part of my argument was matter that was presented through lay witnesses at the PCR hearing and as part of the claim, a habeas claim that everyone agrees is not defaulted. And that's whether or not lay witness testimony would have changed the outcome of the sentencing hearing. And even when I talk about Mikhail Motti's deep depression in my opening argument, I wasn't talking about anything a psychiatrist or a psychologist or a social worker said. I talked about what teachers observed when they looked into Mikhail Motti's eyes, what people heard when Mikhail Motti said that he wanted to have a gun from a police officer to kill himself. That when Mikhail Motti was asked, what is your, one wish in life? For my family to be reunited. And when that person, probably realizing that that was not realistic, asked him, what would your second wish be? To kill myself, to jump off a bridge, to shoot myself, or to use my bow and arrows to kill myself. And while in my heart of hearts, I would like for this court to find a path to consider some of the materials that were not presented, some of the claims that were not presented to the South Carolina Supreme Court. Even if you don't find that path, the testimony that was presented by these capable PCR lawyers who actually did talk to and listen to these lay witnesses is more than enough to establish both the deficient performance and the prejudice prong of Strickland. The PCR judge's order.
Counsel, let me ask you, I wanted to go back to our discussion in your opening presentation when we were talking about Ms. Hammock, and I went back and looked at her testimony. and she told the sentencing judge that Mr. Mahdi has been traumatized throughout his entire life and that he's had an impact on his inability to make good choices, to have a good sense of himself, and to behave according to societal norms. He's a young man who's been abused and neglected. He suffers from abandonment. He's never been exposed to the right kind of socialization. He has poor self-esteem. He has a poor history of school progress, a poor sense of self. He was neglected. He was abandoned. He suffered from poor parenting and was likely to end up in a situation where he's out of control and it does damage to himself and others. He never really had a chance to develop. Is any of that inaccurate?
I think that's accurate, Judge, but those are only conclusions. Part of the claim that was presented to the state Supreme Court was that actual facts that are underlying that was not investigated and presented, and that those stories are engineered into our DNA. They have effects on people who are listening to the stories. The factual information to support those conclusions was not there. I also look back at Ms. Hammock's testimony while the state was arguing, and it was a very narrow list of witnesses that she interviewed. And on page 1596 of the joint appendix, she said that all she had was, this is at line 7, I reviewed a synopsis of his school records and reviewed a report from his mental health and involuntary admission in Virginia. And then she says in Baltimore. So, trial counsel gave her very few tools to do anything with that.
Yeah, this is exactly what I reference. All these people supposedly, the report doesn't it's interesting, but anyway, but for example, I'm glad Judge A.G. asked a good question to follow up on that in terms of he lists those things he read, matter of fact, verbatim, and it shows the problem in this case that yes, it may be true that equals, as you say, a conclusion trauma, but to say it's trauma and not explain what it is at all. I mean, trauma could be, it ranges from, you went to bed and couldn't play with toys at McDonald's or whatever. Not McDonald's, but you like fast food, whatever you didn't get, that was trauma. No. You can't say, in other words, social school progress doesn't get anywhere near to explain being taken out of school when you're at fourth grade. And I don't know any investigation whether there was any follow-up at all in terms of did the parent report any progress at all. To just call that school progress is just putting a label on something. As we all know, we say it all the time. We say all counsel did was just have these conclusory arguments, but nothing there. You need something there. And it's not enough to just tick off the number of hours you spent. You're right. You look at it very narrow. That's what people actually talk to. And who, for example, did you get the information from about when he was waiting, anticipating that his mother be, reunion? Then what you account for the record shows, at least that was presented about his mother in the situation with that reunion. Where did that come from?
I think that came from family members' lay witness testimony. Right,
lay witness testimony.
Right.
And just to say, I talked to the whole family and nothing else, nothing was redeemable from there. Well, that belies from the record. I mean, the only way to believe that almost stuff is just not to read it. But go ahead, you finish up.
I would just
follow up on that real quick, because I thought the story, I just want to make sure I understand. And so if you could just give me slightly more on the reunion story, I understood that was information that was developed during the mitigation investigation from family witnesses. You said it was also new evidence from the lay witnesses that they also talked about it. Which lay witness talked about that reunion?
I believe that it was, some of the aunts that testified. And I know the district court looked at the claim that was presented to the state Supreme Court very narrowly, but the family member lay witness testimony was also presented as part of the background to the state Supreme Court.
So I just so I'm clear, I just want to be able to go find it in the record. This is a heavy record to go through, and I'm just asking for a little help. Or did any of the 7 lay witnesses that we've mainly been talking about today, did any of those 7 talk about the reunion with the mother?
Well, I think that came from the aunts that testified at the hearing, and that was part of the family background that was presented to the PCR judge and presented as background to the state Supreme Court in the direct appeal.
Right. So those were the witnesses that Ms. Munn had talked to before the trial.
But that information was not presented.
I wasn't trying to, this was not a critique. I'm just literally trying to understand where the information is coming from. That's all.
And how do you know she had that information? You got to understand what the question what Judge Richardson is asking you. He's trying to he's asking you, was it known and investigated? Making that the first, you got to be very careful in terms of the questions asked of you.
Yeah.
The question was it investigated versus whether or not it was available and it was used. So the question is in the record that she had that information?
I don't think there's anything in the record that she had.
I didn't think so either. But you have to be very careful when you answer questions, counsel.
Yes, sir. And I think that, I did acknowledge at the beginning that, some of the witnesses that testified at the PCR hearing were interviewed, but they were interviewed incompetently, and that didn't lead to obtaining the information that could be followed up on in an investigation. Could I have just a few seconds to comment?
Yes, you may. Yes, you may.
Your funding question, Chief Judge. I think that, after the Iestes decision from the Supreme Court, Martinez, Triviani, this court's opinion in Juniper, you definitely have to look at that statute differently. And the case that the district court relied on,
the right case, yeah,
James Loan is outdated. I mean, I don't criticize it for when it was decided at the time, but a key component of that case was the inability to expand the record that we now have with Martinez. And I think Your Honor makes a good point that you don't really know what's going to happen until you investigate it. And I know things are changing because we have a capital habeas unit being formed now in the Fourth Circuit. But at the time, when you're trying to put a budget together for how you're going to handle one of these cases, at that point, even the lawyers, even though you're informed by your review of the case, you don't know where things are going to lead until you start doing the investigation. And that's what happened here. And that's why we made our motion for that type of funding at the stage that we did.
Right. And that alone, in terms of the standard, not the incorrect standard for the funding, would excuse in terms of the Martinez and those, because that's not right there, because then you have to go and find out what, if that's correct, what's available, then that would excuse the default in the Martinez aspect and other IAC claims, which include the lay witness and all those other things. So that becomes an important aspect of it, getting that wrong as a matter of law.
And I think that our supplemental information that we provided to the district court is, a proffer of a separate claim that we would have been able to raise if the funding panned out, and the expert was able to provide useful testimony.
Absolutely. All right. Thank you so much. Mr. Gross, I noted that you're a court opponent. I just want to take to express specifically our appreciation. Our court could not function without lawyers like yourselves who take on these cases. We appreciate that. And Ms. Brown, we note your able representation of the state and presentation, and both counsel did a fine job representing their positions here today. Wish we could come down and shake your hands. We cannot, but know nonetheless that we very much appreciate your being here. We're hoping that you will be safe and stay well. Take care, counsel.
Thank you, Your Honor.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Counsel Turno, you may proceed.
Morning, Your Honors, and may it please the court. My name is Lai Paterno, and I represent petitioner appellant James Richardson. The single most effective way to rebut this eyewitness-based prosecution was to introduce an expert to cast doubt on the reliability of those eyewitness identifications. Mr. Richardson was robbed of that opportunity for one of two unconstitutional reasons. First, the state court arbitrarily excluded the critical testimony of Mr. Richardson's well-qualified eyewitness identification expert, not because of any balance of probative value or unfair prejudice, but because of her failure to observe the live in-court testimony of both parties' witnesses. Alternatively, Mr. Richardson's trial counsel was objectively unreasonable in failing to appreciate and act on that admissibility requirement to ensure that the expert observed both parties' witnesses. But no court has even reviewed the merits of that ineffective assistance claim. The procedural exclusion of Mr. Richardson's key evidence is compounded by affidavits indicating that the jury railroaded the only Black male juror because he was a Black man. The district court's refusal to at least hold an evidentiary hearing on the racial animus claim cannot be squared with that juror's consistent insistence that racial animus is, quote, the reason Mr. Richardson was convicted. I'm happy to proceed by discussing those three issues in the order in which the briefs presented them, but of course, I'm happy to take any questions from the court along the way as well.
Thank you.
The first issue presented in this case, Your Honors, is the state court's deprivation of Mr. Richardson's meaningful opportunity to present a complete defense. Here, the state's only direct evidence consisted of the inconsistent and inconclusive eyewitness testimony. Yet the trial court excluded the testimony of Mr. Richardson's well-qualified eyewitness identification expert, who would have testified about the very circumstances that this court in the Harris decision made clear provided a legitimate basis for an eyewitness identification expert to help the jury. These are circumstances like the effect of stress, the effect of alcohol, cross-racial identification, how exposure to media could affect eyewitnesses' memory and confidence, how a lapse in time since the event in question and the witness's statement could affect the eyewitness's accuracy, or confidence and memory. But Mr. Richardson was deprived of the opportunity to present that witness, not because the trial court identified any limit on its probative value or because the trial court identified any risk of unfair prejudice. The only reason the trial court excluded Dr. Van Wallendaal's testimony was because that expert had not seen all of the eyewitnesses' live in-court testimony. And that's clear from the—
Counsel, can I ask, so I want to make sure I understand your argument here. And even if I accepted that you could read the state court's ruling to be as limited as you suggest, we've been instructed repeatedly that we don't read state court opinions as narrowly as we possibly can. In fact, quite to the contrary in the habeas context. And it strikes me that probably the best reading, but at least a plausible reading, was that was evidence, or that was information that was considered as part of the 403 balancing. Help me understand why that's not the way to look at it, and what's wrong with that argument from your perspective.
Sure, Judge Richardson, thank you for your question. To be clear, we're not quibbling over the state court's 403 balancing. Our position is the state never engaged in that. The state court never engaged in that balancing. And that's clear from the record. It's clear from the state court's own rulings. The trial court dealt with this issue in 3 sentences. At JA 2012, the state court says, regarding the testimony proffered in the voir dire of Dr. Lori Van Wallendaal, the court finds that the witness has visited the scene and reviewed the statements and has reviewed the lineup materials dealing with discovery in this case. The court finds that she has not interviewed all the witnesses and has not observed all the eyewitness testimony. And the court concludes the probative value is outweighed by undue prejudice. And the Court of Appeals repeats that finding, but then goes on to add Since Dr. Van Wallendaal did not hear the testimony of the defense witnesses, she would have only testified about the reliability of the state's witness identifications. Therefore, the trial court did not abuse its discretion by concluding that the testimony would have been unfairly prejudicial. Your Honors, this was the basis for the state's objection to Dr. Van Wallendaal's testimony. At JA 2011, the state urged the court saying, Judge, I think that had Dr. Van Wallendaal heard every witness in this case and interviewed every witness in this case, perhaps even then we would object to it, but at least it would be across the board. She would interview every witness, both defense and the state.
What I'm saying, man, I've read it, right? I don't need you to read it to me. The point of that is that, yes, that is the fact. That is the fact that is going into the 403 balancing. Right? Every time you do a 403 balancing, you're considering an array of facts. They highlight that fact, but what you seem to suggest that we have to read the appellate court decision, which talks about balancing. We've got to read the trial court's decision as only about that single fact. That seems like an unduly narrow read. And tell me, I guess mine is sort of more the legal point of why do we not give it the benefit of the doubt when it appears it could at least plausibly be read that way?
Well, Your Honor, certainly on habeas, this court does provide deference to the state court. But here, I think that it's impossible to read the court's decision as connecting that factor and any of the factors the court talks about with the requisite balancing it was required to do under Rule 403. The court doesn't talk about how the fact that Dr. Van Wallendaal had not.
But you do agree that it was excluded under Rule 403.
Oh, yes, sir. Yes, sir. It was excluded under Rule 403, but that's the same as in Holmes and the Supreme Court's decision in Holmes. The South Carolina Supreme Court there affirmed the exclusion of evidence under Rule 403, and the Supreme Court said that the exclusion was arbitrary because the court did not focus on balancing probative value and prejudice. Instead, the rule there was something called, the court applied Rule 403 through something called the Gregory Rule, and the court said that that specific application of Rule 403 was arbitrary and disproportionate to the purpose of Rule 403. And here, the North Carolina courts make clear that the purpose of Rule 403 is to ensure that, in this kind of circumstance, to ensure that an expert witness can provide appreciable help to the jury. And our point is that by excluding the witness based on her failure to observe all the eyewitnesses, the court didn't link that factor to determining whether or not the expert could have provided appreciable help to the jury. It didn't perform the kind of balancing that the courts are required to do under Rule 403, and that Holmes makes clear when a court applies Rule 403, it actually has to engage that kind of balancing. And so we don't contest that the court applied 403 or even that the court has a lot of discretion, but our point is that the court abuses that discretion necessarily when it fails to conduct the balancing required under that. And we think here there's simply no connection between the facts that the court stated and either any limits on the probative value or any risk of unfair prejudice. And if you look at the voir dire, where Dr. Van Wallendaal explained what she would be testifying to, that becomes clear. She would have helped the jury to understand how, in this case, for example, where the incident happened in the blink of an eye, a car zoomed by, it was 2 a.m., it was dark, all the witnesses had been consuming alcohol, it's at a bar, at a nightclub, there had been a fight, everyone's stressed. Dr. Van Wallendaal would have been able to explain to the witnesses how, for example, those circumstances leave gaps often in witnesses' memory. And they have this expectation factor where they fill in those gaps with different facts maybe they do recall from the evening. So for example, if they had seen my client in an altercation earlier in the evening, perhaps they fill in those gaps about who was running to the car or maybe even who was in the car based on that prior information and not based on accurate memory of the actual incident. And that's information that the jury could have used and certainly the defense would have used to undermine the state's prosecution here. But Mr. Richardson was not allowed to do that. And there's no question in this case, Your Honor, that the state's prosecution turned on eyewitness evidence. And you don't have to take my word for that. The state told the jury the way we proved this case was through having lots of eyewitness testimony. And it not only told the jury that in closing, but then it marched through all the eyewitnesses' testimony. It bolstered the eyewitnesses' credibility. It said things like the state has a duty to put credible witnesses on the stand. Our witnesses could not have testified if they were not credible. The state told the jury that. The state went on to then exploit the very circumstances that Dr. Van Wallendaal would have testified about. For example, the state said, here, these kids saw an event that's seared in their memory. They're never going to see anything like this. How could they, ever forget this? And in fact, Dr. Van Wallendaal would have testified that it's the exact opposite, that because of the stress of the situation, there actually were probably holes in memory, and it inflated the individual's confidence, and that they might have pulled information from earlier in the evening, or also from the extensive media exposure. The record makes plain, Your Honor, that immediately after the shooting, the bar owner here went to the internet, pulled up my client's picture based on his involvement in a prior fight, and gave that picture to the police. And within hours, there were statements by the police saying, we know that Mr. Richardson did this. We have the death penalty in North Carolina. There were wanted posters of my client all over town. There was media exposure, extensive media exposure all over the newspapers and in the news. And several of the witnesses conceded that they had been exposed to that media, both before they made some of them before they ever made an initial statement, and certainly before they testified in the case. And Dr. Van Wallendaal would have been able to testify to all of that information and help the jury to better understand the circumstances. Yes, Your Honor.
You're coming up on time, and I just had two sort of factual questions I wanted to be sure that I understand. For your second argument, the ineffective assistance of counsel claim, and you argued cause and prejudice, you are not arguing, I take it, that the cause and prejudice comes from ineffective assistance of appellate direct appeal counsel.
That's right, Your Honor. That's right.
I didn't think so. I just want to make sure. And then, sorry, one other question, and then I'll let you get back to the other things, but I'll make sure that I understand it. In the racial animus claim, you argue on appeal that this is a new claim because it was failed to be developed by the state PCR court, and it should get de novo review. When I look below at both the habeas application and the Rule 59E filings, I don't see any suggestion of that. In fact, I see the argument that this is an improper application under 2254D, not that this is a new claim subject to de novo review. Can you point me in the record where you made that argument below? And obviously, I don't mean you personally, but where your client made that argument below?
Well, I think you're right, Your Honor, that my client below argued that this was an unreasonable application of federal law. And we think that because as you mentioned on appeal, we argue that because the state court didn't allow the factual development here to occur, that under this court's cases in Winston 1 and Winston 2, that means the trial court, or excuse me, the state court never decided this issue on the merits. But even if this court finds that de novo review isn't appropriate, I think for the reasons we argue that Pino Rodriguez did not announce a new rule, those are the same reasons why the long line of precedent explaining that racial animus cannot infect a jury verdict, that long line of precedent surely was clearly established prior to my client's conviction in this case. But here, as you mentioned, Your Honor, no court has ever even reviewed and considered the affidavits. And so that's all we're seeking on the racial animus claim, is for an opportunity for my client to be able to present those affidavits and have an evidentiary hearing pertaining to the statements. And they're pretty egregious statements in there, where the juror Anderson says that he was pressured by these other jurors who were yelling and screaming and accusing him of voting not guilty only because he was Black. And he leaves no doubt in those affidavits that he ultimately was pressured to change his vote from not guilty to guilty because of the racial animus, and specifically says that that is the reason that Mr. Richardson was convicted. So I see that.
I'm just going to follow up with one, Chief, if I beg
Oh,
to.
sure, go ahead. I have some questions too.
With respect to the affidavits, given Penholster, what argument was made, since they didn't argue it was a new claim below, what is the argument that they relied upon below that we can look to for admitting the new affidavits, right? So I understand your argument now on appeal is that it's a new claim, so therefore it's not barred by Cullen. I at least understand that argument. But below, they don't make that argument below. They seem to just say they should come in without an explanation. Can you point me to where I ought to look for what argument he made below about why these, I think 2 or 3 Anderson affidavits ought to come in, the new ones, not the original one?
That's right, Your Honor. The first affidavit, to be clear, Mr. Anderson's first affidavit was before the state court. And we think that's sufficient here. The other 2 affidavits make clear the kind of testimony that could come out in an evidentiary hearing. But the first affidavit was certainly before the state court. And there's no question about that. The state court refused to consider it and said he could not consider it. But there's no question that affidavit is in the record. You're right that the district court granted a motion to strike the second affidavit, Mr. Anderson's second affidavit, and the third affidavit, I don't believe there was ever any ruling on the third affidavit. That was provided on the Rule 59E motion. So, Your Honor, if there are no further questions,
in this record, AG has a question. Go ahead.
I just want to be sure I understand your argument on the racial animus part. Your argument is not that the speaking juror, whoever that was, had animus toward the defendant. The animus was toward the other juror, Anderson.
Well, Your Honor, we argue both. It's clear from the affidavits that the other jurors directed racial animus towards juror Anderson. That is what he says, and there's no question.
Well, if we're going with the affidavit that was before the PCR court, I don't remember anything that was directed toward the defendant, and that there was only one speaking juror. So it's on that basis that you would have to claim the speaking juror had animus. That is clearly a Pina Rodriguez claim. But the claim that the speaking juror did not have animus toward the defendant, but animus toward a specific defendant, is there any case after Pina Rodriguez that has adopted that line of reasoning?
Well, we're not aware of a case, Your Honor, that adopts that reasoning. There certainly are cases, for example, the Buck case just from a few years ago in the Supreme Court that makes clear that racial animus, the Supreme Court is committed to eradicating racial animus from jury trials, period. And so we think that even if the racial animus were not directed directly to our client, we still think that it warrants an evidentiary hearing to determine whether racial animus was nevertheless the but-for cause of the guilty verdict here. But to be clear, we do argue both, Your Honor. We think that if the other jurors directed racial animus to Mr. Anderson because he was a Black man, then it blinks reality to assume that those same jurors did not project the same racial animus towards my client, who is also a Black man. But then the second issue is, as you described it, Your Honor, it's whether racial animus was a significant factor in the guilty verdict here. And we think that the affidavits show that it was, because Mr. Anderson would not have voted guilty but for the racial animus.
And we say racial animus, we call it racial animus. It's almost euphemistic to even call it that. We're talking about, of course, we don't know because we haven't been allowed to have evidence you're hearing to dig into it, but Mr. Anderson said that he was told that because he's Black, because you're Black, only because you're Black, That's the only reason why you're voting the way you are. Nothing about your intelligence, about looking at the evidence, anything, because you are Black. I can't think of any more insidious than that. We allow that, and that's just passed up. Well, that's not to the person, and this is not this case, but to say that that's not to the defendant, just to that juror, it would be like somebody saying that you're on a jury and they say, "Listen, I tell you, you need to vote the way I want you to vote," and use racial type things and say that. And you say, well, no, there was no animus because it was not directed toward the defendant. The whole point is an independent juror, that we protect them a great deal. We don't want people to talk to them. We sequester them sometimes. They can't go back to their homes. And here's a case where you're told directly, and more importantly in this case, because there was an Allen charge. Because the Allen charge, of course, as a defense lawyer, that's the worst charge there is. Because in so many words, it's saying, listen, you still have your independent judgment, but you ought to listen to what the other people say. That intensified being told, you're only doing this because you're Black. And that stands on a court of justice in America in 2021? To just undermine his intelligence, everything. Or as somebody tell me, you're a woman just because you're a woman, that's the only why you see it that way. That's horrible. It's insidious. I mean, and we've recognized for a long time that racial animus, in terms of a jury's independence and to be able to do so, is a part of our DNA as our justice, I would hope. It's a watershed rule. It's not just new. I think Pina Rodriguez does have retroactive impact if you look at it from just the analysis of it. But this is incredible that this animus is only somehow cabined just to that juror and is insulated from the whole process of a fair juror. How could he have a fair trial when one of his jurors, or it's alleged, we don't know if it's true or not, was just taken out in terms of that because you're Black? You're only doing that. And the court didn't know that, but it charged them, you need to listen to your fellow jurors. And based on this is what's being told to me by my fellow jurors. You need to fall in line because you're Black. That's why you're not falling in line. That's the case. We call it just racial animus. Call it what it is. This is a court of fact and truth. Let's at least adjudicate the case on the truth, not just animus that's floating in the air. It's one of the most insidious things I can imagine.
That's right, Judge Gregory. And again, we're asking just for an evidentiary hearing for the opportunity to bring out the truth that you're talking about. The juror Anderson has never had an opportunity to testify about these statements, and that's what we're seeking on remand.
All right. Thank you. Mr. Vlahos, I'm not pronouncing that correctly.
Thank you, Your Honor. Vlahos, yes, sir.
Vlahos, yes.
Thank you.
Thank you.
May it please the court, I'm Nick Vlahos, Special Deputy Attorney General, North Carolina Department of Justice, for the respondent. I'm going to start with issue 3, where the court left off just now. Racial animus and stereotyping, like the kind described in Pina Rodriguez versus Colorado, is abhorrent in all respects and has no place in our criminal justice system. But Richardson's case is not like Pina Rodriguez. Instead, Richardson's case is substantially similar to a matter this court addressed in United States versus Burchett, a decision based on Pina Rodriguez. Both the United States Supreme Court and this court have recognized that a juror coming forward with compelling evidence that another juror made clear and explicit statements indicating that racial animus was a significant motivating factor in that juror's vote to convict is a threshold showing a litigant must make to obtain relief under the narrow exception to the no impeachment rule announced in Pina Rodriguez versus Colorado. Now in Burchett, after a federal jury convicted the defendant, an African-American male, of several firearms and drug-related offenses, he requested leave to interview jurors for evidence of racial animus. The district court denied his request and Burchett appealed. On appeal, Burchett argued he was constitutionally entitled to interview jurors under Pena-Rodriguez because after the verdict, a male African-American juror approached the defense team and told them about statements other jurors made potentially suggesting racial animus. In concluding that the district court did not abuse its discretion in denying Burchett's request to interview jurors in search of evidence that could be used to impeach the jury's verdict, this court found, even accepting arguendo, that all the proffered evidence was reliable. None of the statements here required the district court to find that defendant would likely uncover evidence that racial animus was a significant motivating factor in the jury's vote to convict. Especially relevant to Richardson's case, this court reached the following conclusions regarding evidence proffered in Burchett. Okay, regarding evidence that a white lady said, the two of you are only doing this because assuming that the white lady was a juror, these statements need not suggest that the speaker's racial animus in any way impacted her vote to convict. They can reasonably be interpreted by the district court as a sort of offhand comments that the Supreme Court held are insufficient to overcome the no impeachment rule. And they certainly fall short of the statements presented in Pena-Rodriguez, in which a juror allegedly argued for a guilty verdict because the defendant was Mexican. That's the words of this court. Another part of this court's decision in Burchett said, regarding Burchett, or not the said, it's regarding Burchett's argument that a female African-American juror's request to be excused from the jury shortly after the trial court gave an Allen charge and shortly before the final verdict provides good cause to interview jurors. This court stated that hardly required the trial court to believe that one juror's request to be excused provides compelling evidence that another made clear statements reflecting a vote based on racial animus. And
Counsel,
Mr. Richardson.
Thank you so much for that. You did a great job of Burchett looking at, and the more you talk, the more to me, I want you to address it. It's clearly how it's in opposite here. Here, there was a question there, you had to speculate as to what impact the person who made the comment, what impact it had on her decision. We didn't know. We don't know what impact it was, somebody requesting to be excused after an Allen charge, we don't know. But here, this is different. This is a person saying that, at least that we don't know, that what we have fact finding for. I was attacked because I was Black and told that's the sole reason I was making the decision. Not only that, in the context of this Allen charge, and you have also that is, I changed my vote solely because of this. So we don't have to speculate here. Burchett is clearly not controlling here because what was missing there is here. He said, not only she said it to me, he didn't say she said it, period. She said it, I resisted it, and finally I was born down that I voted even when I didn't believe, in fact, he was guilty. That is awesome. You can't just excuse something away. You know, a fact is a stubborn truth. Some facts you just whisk away and turn your eye, but truth, it's stubborn, it's stubborn. He said, that's how I voted. Because I was made to feel that because of my color, Black, I could not be independent and I needed to do this. That's what he said. So how do we counsel, how's Burchett controlling that? We know, at least as alleged, what impact it had. Am I correct, counsel? Was a unanimous verdict required?
Your Honor, you're correct that a unanimous verdict is required.
Am I correct then if one of those jurors was intimidated because of his color and directly that and his will was so born that would have an impact on the vote or on the verdict? If he still believed that a person was innocent but did so because of the way he was attacked because of his color? How is Burchett controlling on these facts?
Your Honor, because Burchett and Pena Rodriguez require a threshold showing before judicial inquiry, before the judges can step into the jury room during deliberations and find out what's going on there. First, a threshold has to be met. And the threshold was not met in this case.
No. What is the threshold?
The threshold is that a juror coming forward with compelling evidence that another juror made clear and explicit statements indicating that racial animus was a significant motivating factor in that juror's vote to convict.
First of all, every case is not going to be on all fours, but you're telling me that it's more powerful to have somebody say, well, they said something that may have indicated how they would have voted. That's more powerful than evidence that they said something based solely on race that made another juror intimidated to vote for something they didn't believe in? How could that be? That's like Holmes said, that the life of the law is not logic, it's experience. I don't see how anybody could come with that, any common sense could come up that wouldn't be more powerful. You're sitting there, think about it, you're sitting in the room and everybody look at you like, you're black. You you're only doing this because you're black. And you hear this. And I suppose you have to be someone who's been in a situation where a dominant minority, and then sort of just say that. And then he said, and he voted. Didn't he try to get off the jury?
Yes, Your Honor.
Right, he tried. That corroborates how deep it was. That's all corroboration here. There's none so blind as the one who will not see. Go ahead, counsel.
Yeah, Your Honor. Your Honor, first, I think Burchett is applicable to this case, Your Honor. And the second thing, what you're describing is not the juror's statement of racial animus. What you're describing is Mr. Anderson's, in this case, reaction to a question that somebody asked him. Okay, the statements in Burchett were statements and these are questions. That's one thing. But another thing on top of that, the United States Supreme Court never intended Pena Rodriguez to be interpreted as Richardson is arguing in this case. They never intended that. And we know that. In their opinion, they said, right after they gave the rule, they said not every offhand comment indicating racial bias or hostility will justify setting aside the no impeachment bar to allow further judicial inquiry. For the inquiry to proceed, there must be a showing that one or more jurors made statements exhibiting overt racial bias that cast serious doubt on the fairness and impartiality of the jury's deliberations and resulting verdict. To qualify, the statement must tend to show that racial animus was a significant motivating factor in the juror's vote to convict.
Well, it is. You see, you just said that. You have to look at it in the context of the jury. It had an impact on the jury's verdict, because the juror's verdict is influenced by any one of them. And are you saying that the statement was not racial animus? Did not reflect racial animus? Are you saying that?
Your Honor, I'm saying that it was a question asking.
No, I'm asking you.
Yes, sir.
Are you saying that that's not evidence of racial animus when you tell somebody you're only voting this way because you're black? Tell me, I want you to answer that question. Are you saying that's not racial animus?
The question you're asking me.
Yeah, and I want an answer to my question.
Yes, sir. Could it be?
Yes or yes?
You're saying, is it?
No,
yes,
no.
I understand.
No. You understand it, so answer my question. Is that evidencing racial animus? And we don't know if it's said because he's been barred so far from getting into dig into this. But are you saying that that statement does not evidence racial animus?
I'm saying that it can.
No, it can?
Yes, Your Honor.
But it can based on what? Well, what would be the option that is not?
Well, Your Honor was talking about, I think.
I'm talking about my question. My question is, give me the option when it's not. You said it can, then I know logic that would suggest that there are other circumstances where it's not. Give me the one when it's not racial animals.
Well, hear that? The question in this case that was posed to Mr. Anderson was not based on racial animus. It was based on a desire to find out why he was voting not guilty.
Why? Oh my, she didn't say, she told, but he said that you were told that was the reason. Are you changing the facts?
No, Your Honor, not at all.
Oh, I think he said you voting that way because you're Black.
That's not what he said. They asked a question. Are you voting this way because, do you know Richardson's family? Are you voting this way because you're a Black male about the same age as Richardson? They weren't discriminating on him based on his age. They weren't discriminating on him based on who he knew, and they weren't discriminating on him based on his race. They were asking, in light of all this evidence showing Richardson's guilt, why are you continuing to tell us that he's not guilty now? Let's talk about this. Let's open discourse. Let's speak freely about it. And Your Honor, that's, if you take.
I see. I see. I understand.
Well, if you take Richardson.
I guess the only way the court is to rule for you is to believe what you just said, that that's not racial animus.
No, Your Honor.
It's just like the argument that Thurgood Marshall made in Brown. He said the only way that respondents can win this case, you have to believe there's something intrinsic about Black people and be separated in schools. So you're saying that this has nothing to do with race, not even a question. Is that right?
Your Honor, I'm saying if this court follows a clearly established United States Supreme Court precedent, then the state prevails in this case. Okay, these are the United States Supreme Court words, not my words. Not every offhand comment indicating racial bias or hostility will justify setting aside the no impeachment bar. Okay, well, just because a statement has racial animus or hostility does not mean that it automatically you get rid of the no impeachment bar. The United States Supreme Court was very careful when carving out an exception to the no impeachment rule to use a scalpel and not a meat cleaver to try to do so, because juries are that important. Our entire system depends upon it. Our jury system depends upon the willingness of jurors to serve and speak freely during deliberations. And as this court recognized in Burchett, the willingness of jurors to serve and to speak freely during deliberations depends on the no impeachment principle. In the United States Supreme Court's words, the no impeachment rule promotes full and vigorous discussion by providing jurors with considerable assurance that after being discharged, they will not be summoned to recount their deliberations, and they will not otherwise be harassed or annoyed by litigants seeking to challenge the verdict. The rule gives stability and finality to verdicts. And, Your Honor, that's why the United States Supreme Court separated.
I understand what the Supreme Court said. So I see. So we have to protect statements like this.
No, Your Honor. What I'm saying is the United States Supreme Court created two categories. Okay. In one category are offhand comments indicating racial bias or hostility. On the other side of that is a statement just like what happened in Pena Rodriguez versus Colorado, where that juror said, I believe this Mexican guy committed this crime because he's Mexican. And I know from my job in law enforcement, which are essentially the fact, that Mexican guys are more forward with women, that they're more likely to commit sexual offenses against women, so I'm going to find him guilty. That's not anything near what happened in this case, in Richardson's case, Your Honor.
Well,
that's the state's argument.
What happened in this case was that a juror changed his mind and voted guilty when he didn't believe that he was guilty. That's not a serious consequence of this?
Your Honor, I'm not arguing that it's not a serious consequence for somebody.
It's the most serious consequence there is, isn't there?
It is, Your Honor. It is.
Absolutely. It was not the same facts, but the consequences are very serious unless people don't care. If you don't care, I don't think the Supreme, for example, when you talk about cases like this, they're very charged cases. And you're talking about you're right. Jurors ought to be able to come down there. And I don't think they ought to come down there thinking that somebody's going to question them because of their color or their sex or their ethnicity or anything about their sexual orientation, whatever. They ought to come there as stand like any other citizen and appear. And yes, debate the facts of the case. Yeah, we want a robust fact. So if you say something like, oh my goodness, you'll be stupid to believe that what that witness said on the thing. Well, that's banter. But we're not talking about banter. We're talking about a conclusive statement and questions that are put to that, it's like, I guess you have to be, have some experience in terms of minority, but you said with just a question, for example, people ask you questions like, do you live here? Well, I didn't say you didn't live here, but you didn't ask anybody else that they live in, but you talked to a black person, walk up, do you live here? You said, well, I just asked the question. And you said, oh, that was nothing about race. I just asked the question. And to a point where a juror just felt I had to succumb to this and vote guilty when I believed and still believe innocence. But that's okay. But I understand your position. You made it clear when you.
Yes, sir. Also, if this court's to interpret Pena Rodriguez in that manner that's suggested by Mr. Richardson, then any individual juror would be able to come back and impeach the entire jury's verdict post-conviction just by coming up and saying, I felt racially pressured because so-and-so said this. That's not what Pena Rodriguez was designed to do, Your Honor. That's the state's position.
Oh, I see. You're going with the slippery slope argument now. If we allow this door, the door will be so open wide, the jurors will be flocking in saying this. I don't think that's the case. I don't think that's the logic of it, not the consequences of it. It takes a lot for a juror to do this. And a lot of times people are, many times are not quite persuaded fully, but they go on and it's a unanimous verdict. But I agree with you, and that became a cascade, but a slippery slope is a very tenuous way to fin here in terms of when these cases like this, you were talking about investigating it. Never mind. Well, go ahead and finish up.
Your Honor, to go on to another issue, if there are no further questions on this issue.
Ms. Richardson has a question.
Yeah, can you just spend a minute, which is sort of what you got, responding to your colleague on the first claim, not the ineffective assistance of counsel claim, but the claim, yes, a due process violation to have excluded the expert's testimony under 403.
Yes, Your Honor. First of all, just to cut to the chase, based on the overwhelming evidence of guilt presented in state court proceedings, this court should reject both Richardson's expert's witness claim and his ineffective assistance of counsel claim. Richardson was identified as the shooter by Vidal Thorpe, a member of the same race who only had one beer before the shooting, watched no media coverage of the shooting, and knew Richardson because they frequented the same bar for months and played pickup basketball together at a local high school. His being the person who identified Richardson in the car substantially lowers the probative value of an eyewitness identification expert testifying. And Your Honor, not just him, but Jeff Seeley, other people in this case, they knew Richardson from before, okay? Jeff Seeley in particular. He knew Richardson because Richardson bought him a drink and talked to him on the night of the shooting before Richardson got into an altercation with bouncers outside the OP. When Seeley heard Richardson threaten to come back and kill the bouncers, he left because he thought Richardson was serious. As he was leaving, Seeley saw Richardson go to the white BMW, pop the trunk, pull out a handgun, cock it back, and get in the BMW, which drove the wrong way down a one-way street to get to the front of the OP where shots were fired. Rachel Burke agreed with this, or she corroborated this testimony, but she couldn't identify Richardson. And also, Richardson is not the type of person who blends into the crowd. Okay, he was the tallest guy there, and he's a black male with very light skin. Okay, in fact, he had the lightest skin of the group he was in. His brother Andre has slightly darker skin than him. Kyrio Arrington, who was there with him, has much more darker skin than him and had long dreadlocks. So there's,
I got you. I think you're over time. I just
yes, Your Honor.
Give you the opportunity to give a brief response.
No, you keep on your talk. You can go ahead. You were finishing it. He was light skinned. What you said? What you saying? He stood out, right?
He stood out in a crowd, Your Honor. Yes,
and that was responsive to Judge Richardson's question about the funding. That's all a matter of goes to the weight, isn't it? I mean, was that the reason given for not allowing that testimony in terms of the expert?
Your Honor, the reason for not allowing the testimony is that the defense was trying to tailor the testimony. They only wanted their expert to testify as to the state's witnesses, except Thorpe, and not their two witnesses. Their two witnesses I got up there and identified somebody who's clearly not Richardson, but the eyewitness identification expert, and that's the irony of this, the eyewitness identification expert, if she testified, would have undercut their testimony. So you got a defense who's putting on witnesses to say it's not him, but then trying to put on an eyewitness identification expert that will probably end up undercutting their testimony.
You know a rule that says that you have to have equal opportunity when you put on an expert, that if you put on an expert to help you, it's got to also help the other side equally, potentially? I never heard of it like that. I don't, because that's basically what he said. No, you got to interview all of them so that you can put your expert through the test. That's called cross-examination. Obviously, the prosecution is going to say, excuse me, you talked about that, but you didn't say anything about those, did you? That's because you didn't hear them testify, did you? No. I mean, that's the art of advocacy. But that doesn't mean you preclude, lock, stock, and barrel of 403 because it didn't do everything it needed to do. Okay, I got to have my expert testify for you. Hire your own expert. My goodness, the government always puts on a lot of things. It's not because, you can't put this on because that would be unfair to the defendant because you didn't give them a chance to put their DNA on. No, that's what the advocacy is. The defense has to do that, but now the defense, the metric is you can't do this because you haven't done it to be available for the prosecution, their witnesses too. It might help them too, whatever. Or show that against your people. That was the whole point of it. His expert was to show what's against me. I don't have to prove anything. I put them on, but I didn't have to put them on at all. Right? At that point,
that's correct. That's correct.
Put them on. So he was, okay. Well, never mind.
May I respond to that, your question, Your Honor?
No, thank you, Your Honor. I didn't have a question because it's but never mind. Go ahead.
Yes, sir.
Anything else?
Nothing else. It's all in the brief, Your Honor. Thank you.
All right. Very well. Thank you so much. Mr. Paterno.
Thank you, Your Honor. I'd like to address both the racial animus claim and the first claim that Judge Richardson asked about. Taking the racial animus claim first, Judge Gregory, I think you're absolutely correct. The Burchett is nowhere near this case. Obviously here, it wasn't an offhanded comment. The juror makes clear that this was the reason he changed his vote. And he talked about I think my colleague tries to strip it of the context, but the affidavits make clear that he was, quote, bombarded by the hostile attitude of these other jurors. And he says he was scared. He was scared for his kids. This was a case that was racially charged. The whole community knew about this case, was involved in this case. As explained, there was extensive media coverage. He had reason to fear from the other the other jurors' racial animus. And as Your Honor mentioned, he tried to get off the jury, and the trial court sent him back and said, figure this out. You have to reach the unanimous jury verdict. And another reason it's different, Your Honors, is that my colleague talked about how in Burchett.
There's two things, though. You just mentioned the juror getting off and the Allen charge, or by reference, but both of those were in Burchett too, right? There was a African-American juror who tried to get off, and there was a Allen charge in Burchett, right? Am I remembering that correctly?
I think that's right, Your Honor, if I recall those facts correctly. But another key difference with Burchett is that there the statements from the juror, as my colleague mentioned, are these comments after the fact from a juror just minutes later to the defense counsel. Here, it's that we're not seeking to interview additional witnesses. That's the relief that was requested in Burchett. Here, we have a juror who came forward on his own volition and swore in an affidavit, and now in 3 affidavits, swore to the facts that are included in there. And so all of my colleagues' worries about slippery slope or comments about forcing jurors to come back and testify, that's really not an issue here. We have a juror who's begging to testify and say that an injustice was done here. The only reason that Mr. Richardson was convicted was because of racial animus. And I think my colleagues' comments about how these statements could reflect racial animus, that's just even more reason for the need for an evidentiary hearing here, where again, we're not asking to overturn the verdict based on this. At this stage, we're just asking for an evidentiary hearing so the truth can emerge. And on the second issues, Your Honor, on the due process claim, my friend on the other side went straight to prejudice and said that there was an overwhelming evidence of guilt. And he mentioned Vidal Thorpe. Well, Your Honors, Vidal Thorpe's, it's important to put it in context. He did not come forward until 22 months after the incident. Mr. Vlahos mentioned that he was familiar with my client. Well, if he was familiar with my client and saw that this had happened, you would think he would have come right away. But in any event, he waited until 2 weeks before trial when he was coaching the prosecutor's son or child on a soccer team and made this statement. And that is absolutely the kind of circumstance that Dr. Van Wallendaal's testimony would have helped the jury to appreciate, how that almost 2-year lapse in time could have affected Vidal Thorpe's memory and his confidence. But the jury was never allowed to hear that. And my colleague mentioned that the defense was trying to tailor the expert witness. Well, of course, as you mentioned, Judge Gregory, that's what litigation is. You try to tailor your witness.
The expert here never interviewed Mr. Thorpe or heard his testimony.
You're right, Your Honor. The expert never saw his live testimony. She did read his testimony, and she read all the statements in the case. She visited the crime scene. She had engaged in extensive case-specific preparation here. But you're right, she did not see Vidal Thorpe's testimony. But that didn't stop the prosecution from asking her about Vidal Thorpe in the voir dire. If you look at the voir dire testimony, the state makes the exact points that Mr. Vlahos is raising here, saying, well, isn't Mr. Thorpe of the same race? And what if Mr. Thorpe only had this many drinks over the night? Those kinds of things. There's no reason, as Judge Gregory mentioned.
I thought trial counsel at the trial told the trial judge that he could not ask the expert witness any questions about Mr. Thorpe.
Well, you're right, Your Honor, that the defense counsel did not plan to ask on direct examination any questions of Dr. Van Wallendaal about Thorpe. But my point is that in voir dire, the state on cross-examination asked Dr. Van Wallendaal about Thorpe. And that shows that if she had been allowed to testify before the jury, the state could have posed those same questions. And even if the state hadn't, here, Dr. Van Wallendaal was not planning to testify about any specific witness's credibility. She could not have testified about that. Rule 608 of the North Carolina Rules of Evidence preclude an expert witness from testifying about a witness's credibility. Here, Dr. Van Wallendaal would have talked about these circumstances, and the jury would have then been equipped to understand how these circumstances cut across the different witnesses and could have applied it to any of the witnesses that the jury had heard. And so the fact that the defense counsel did not plan to ask Dr. Van Wallendaal about Thorpe didn't limit the probative value of her testimony in any way. I see that my time is up, Your Honor. Unless there are any further questions, we'd ask for vacatur, we'd ask for remand, and we'll rest on the briefs.
Thank you so much, counsel. I want to thank you both for your arguments. Well done. We would love to come down and shake your hand. We can't do that, but know very much that we appreciate your arguments, and we hope that you will be safe and continue to do well. Take care, counsel. Thank you.
Thank you, Your Honor. Take care.
All right. Go to take a break, maybe a 5-minute break.
That'd be good. Thank you.
All right. final case for the day.
Okay, I'm going to move them back in, Judge Gregory.
Thank you, Ms. Walker.
It's going to be 1 minute.
Of the petitioner, Jean Pugin. In this categorical approach case, the state offense, Virginia accessory after the fact, sweeps more broadly than the federal offense, which is offense relating to obstruction of justice under 8 U.S.C. 1101A 43. So it is not an aggravated felony under the INA. The BIA erred in concluding otherwise, and its conclusion should be reversed for several reasons. I'd like to turn first to two of the reasons that relate to the BIA's analysis of the federal.
Ariel, can you turn this up a little bit? I can't hear her.
Excuse me. Your Honor, I'm sorry. Was that request to me? Would you like me to turn up my volume?
No, we're adjusting the volume so I can hear you better.
Thank you.
Yeah, we're good.
Okay, I'll continue.
That's
Thanks. So first, there's a baseline problem, and that's with the board's interpretation of 43S as encompassing offenses where an offender intends to interfere with proceedings that do not actually exist, but are merely reasonably foreseeable. The Ninth Circuit held that unambiguously foreclosed by the statute in its 2020 Valenzuela Gallardo decision. The Third Circuit reached a similar conclusion in its 2017 Flores case, and no court has upheld this more expansive interpretation of 43S that's advanced here. But I also want to point out another problem with the BIA's analysis of the federal offense, which is that not only is this interpretation
So
wrong,
if I could ask a threshold question, your view is that offense relating to the obstruction of justice is an unambiguous term?
Yes, Your Honor. And that's consistent with both the Ninth and the Third Circuit's analyses.
Just so that I'm sure I followed, to follow up on that question, what does it, can you just describe for me what you believe it unambiguously means?
It unambiguously requires a specific intent to interfere with a judicial proceeding or another discrete and discernible point in the process of justice, which is what the BIA said for years in the Espinoza-Gonzalez decision.
But it's not limited unambiguously to the U.S. Code type offenses, that the chapter that refers to obstruction.
Your Honor, I think it would be unambiguously limited to those types of offenses. It's obstruction offenses like the ones in the U.S. Code, and I think there is some tension between.
You just didn't mention that when you described what it. And I was just trying to understand what your argument is. So just give me again one more time, just so I can be clear. What is it that it unambiguously means? Is it just it unambiguously requires specific intent, or it unambiguously is of the type that's included in that chapter, which therefore requires specific intent? You understand what I'm saying? I want to understand what you say the words mean. And there seems to be some ambiguity between those two positions.
Yes, Your Honor, I'll try to respond to that, which is the first step of what is ambiguous. The offense relating to obstruction of justice is the words that Congress chose, and it's the title of a chapter in Chapter 73 in the Criminal Code. So we think that reference is clear on the specific issue here. So if there is a Chevron question here,
but can I stop there? But yeah. That's what you think is unambiguously clear, is that it incorporates by reference the U.S. Code provision or chapter or subchapter.
Yes. Yes.
And from that you then get your rule.
Yes.
But there's no cross-reference to Chapter 73 in the Criminal Code, is there?
No, Your Honor, there's not.
And there's no definition in the INA of the term either. Is that correct?
No, Your Honor, the term itself is in the definition section of the INA in the aggravated felony section. And so I think there's a clear, especially since
So
it's
it defines obstruction of justice in the INA?
It appears in the definition section as one of the defined terms that is an aggravated felony under the INA. And so obstruction of justice there is a term of art, as multiple courts have recognized. It sits alongside perjury and bribery, which also refer to criminal code sections. And so it's fairly straightforward, really. And I do want to turn a little bit to a next issue that arises.
Before you turn to that, why do we, if it incorporates this chapter, why is it, you say it incorporates the chapter, term of art. Why then does it include any state law offenses, right? If it really incorporates the federal chapter as a term of art, why does it include any state law offenses?
Your Honor, I think our position is that it refers to those offenses and their state analogs, that an overall structural purpose of the aggravated felony of the INA is to sweep in the state offenses that are the same as the federal offenses, but in a different forum. And so you see.
So what about the phrase "gets me there" unambiguously, right? So your point is that this phrase is unambiguously clear that it incorporates the federal provision, but it's also unambiguously clear that it's not just the federal provisions, it's also some subset of the state provisions. I mean, I'm just having trouble understanding the sort of the steps that you're taking to show the unambiguous clarity that your argument, I think, depends on.
Your Honor, I think that going directly to Chapter 73 and the crimes listed there is not all that complicated. They're all acts about interfering with official proceedings and the processes of justice. And so capturing those offenses and the analogous state offenses, for example, Virginia has an obstruction of justice chapter that has perjury and bribery in it, same as the two offenses listed next to obstruction of justice. And so I think it's a knowable universe. It's a term of art and does refer there. But even if the BIA was allowed to do what it did here and extend to reasonably foreseeable proceedings, which it does, hinging to Section 1512 of Chapter 73, I want to point out a big problem in that analysis that is also determinative of this case in Mr. Pugin's favor. And that is that the BIA's use of this standard that it adopted, reasonably foreseeable, is totally contrary to the law that it claims supports that standard. What I mean is this: when the BIA added interference with reasonably foreseeable proceedings to its definition of the generic crime in the 2018 BIA Valenzuela-Gallardo decision, it did so citing directly to the Supreme Court's Marinello case. And so its use of that term should be consistent with Marinello, but it is definitely not. And I need to give a little background on Marinello here, which is a tax obstruction case from the Supreme Court. But Marinello, while being a tax case, built on prior cases about Chapter 73 offenses, which include Pettibone from 1893, Arthur Anderson, United States versus Aguilar, and all of these rejected government attempts to assign obstruction liability for conduct that could interfere in a proceeding that didn't actually exist. Marinello rejected the government's argument that foreseeability means generalized showing that the defendant could be aware, and I quote, that the IRS might catch on to his unlawful scheme sometime. So it imposed a requirement that of showing a subjective intent to interfere with a particular proceeding. And this reasonable foreseeability test has been used in a variety of Chapter 73 crimes, including by this court in the case called United States versus Young in 2019. So it has meaning, and it is a standard with teeth. Young was a case where the government's position was rejected, and so we know the standard means something. And what it doesn't mean, though, is what the government advances here. In Valenzuela-Gallardo 2, here's what the BIA said the standard means. It means the government needed only to show that an individual acted with the intent to frustrate an investigation or proceeding that might be instituted. That is not the Marinello standard. The government adopts that position here in page 26 of its brief. And in the decision below in this case, the BIA just said that this definition was satisfied because the conduct could have hindered a felon's apprehension, conviction, or punishment. And I want to note on page 42 of the government's brief, what they say is Mr. Pugin fails here because he fails to establish that Virginia has successfully prosecuted a defendant for conduct broader than, quote, frustrating law enforcement. Frustrating law enforcement is a far cry from the particularity and foreseeability requirements of the test from Marinello.
What do you tell me if we're looking at this chapter, assuming the first step that we're only looking at this federal chapter? Tell me about 1510A, and under 1510A, what am I looking at there for an existing investigation?
Your Honor, I apologize. I need to pull that up in front of me.
I'm not. If it's not at mine, maybe you can just do it on rebuttal. I mean, I look at a number of the offenses in the section you're looking at, assuming we get to that section, and they talk about going to law enforcement in the first instance, whether it's healthcare or bankruptcy or otherwise, and so all of those also. I understand your argument, at least about 1512, but 1512 doesn't stand alone. Even if we're looking at the federal chapter, I find it hard to see why each of those offenses requires the existence of an ongoing proceeding as a necessary predicate.
Your Honor, 1510, 1512, and the few provisions that are different perhaps in the character of having an ongoing proceeding are not the majority rule and shouldn't be the basis of the generic offense, would be one response. The second is, and I'd have to look at 1510 specifically, but for 1503, which is a provision the government relies on, and 1512, which is another provision the government relies on as supporting a divorce from the extant proceeding requirement. Both of those have been construed by the Supreme Court as really requiring a pretty serious nexus, first in time and causation between a proceeding and this subjective and particular foreseeability analysis. So they don't get the government where it's trying to go here, which is general intent to frustrate law enforcement. And I want to point out another problem with landing there, which is where the government is going in this case. And I just want to underscore that. It's that it really, when you have a toothless standard, for reasonably foreseeable, we're back where we were in 2016 when the Ninth Circuit vacated the prior BIA Valenzuela-Gallardo decision because it was unconstitutionally vague, that it was not possible to figure out where interference with the process of justice could actually begin, and it would be unadministrable and unfair. The Third Circuit has noted similar problems with too mushy of a standard in this area in the Flores decision. And so that area, that constitutional problem exists if the BIA and the government can proceed with this sort of meaningless Marinello standard that they've advanced here. And both the sort of contrary to law and the constitutional problems here, by the way, resolve this case, whether it's on de novo review or whether we're at Chevron step 2. So we think no matter which path the court takes through this problem, it arrives at the same place.
Counsel, if I could ask you before your time runs out, if we were to just assuming that we agreed with the government that the term was ambiguous and that the BIA had made a reasonable interpretation, talk to us about the categorical match with the Virginia statute.
Yes, Your Honor, there is no categorical match under any of the versions of the federal crime that are advanced here because the Virginia crime just sweeps more broadly. The government standard under their most favorable standard is intent to frustrate law enforcement, but that's not actually an element. A requirement that the prosecution must prove for a conviction is not an element of the Virginia accessory after the fact crime. We know what the elements are, which are the key to the categorical approach from the Virginia Supreme Court's only case on this topic this century, the Dalton case. There's 3 elements, and they numbered 1, 2, 3. That a felony is complete, that the accessory knows that the felon is guilty, and that the accessory renders help to the principal. And then the list stops.
Well, let me ask you this. I guess I would call it a practical question. My guess is in 99% of all the prosecutions in Virginia for this crime, the parties in the court used the Virginia model jury instructions. And those model jury instructions specifically include as a separate element the specific intent provisions from the Wren decision. So is it your view that all of those juries are improperly instructed?
Your Honor, possibly, but I think there's also some missing facts here about when those instructions went into use, how often they're used, and then whether really what is.
Well, they are the model jury instructions, and most of these categorical, modified categorical dilemmas we're called upon to resolve, we are often looking at, well, what happens in the state courts? What does the state Supreme Court say? But what do the jury instructions say? So it seems like to me, if we were to adopt your position, we would be holding in effect that a large number of these state prosecutions are simply invalid.
May I respond, Your Honor? I'm out of time.
No, you may, the question is that our holding will it invalidate anything in Virginia's statute, I guess. That was the question.
No.
But Judge Agee can restate his, but you can answer it if he wants to restate it, but I think.
Well, it wouldn't, obviously, we wouldn't be invalidating the state court determination, but it seems like it would be at odds with what the state courts do.
Your Honor, it isn't for two reasons. One, that if they're put up next to the Supreme Court's direct statements of the elements the jury instructions wouldn't control. But most importantly, that language from Wren and Buck is not a match to any of the proposals from the government here, that you act to elude punishment generally. I mean, the government is trying to drag the generic federal offense to that breadth with this frustrate law enforcement. That's not obstruction of justice. Elude punishment is old and indefinite language, and it describes the act. It describes the act that you have to take to be an accessory. You mow the lawn of a known felon. That's not accessorial. It's a description of the act. It's not an intent element. It's separate from what the generic offense needs to match, and it's separate in substance.
Yeah, in Virginia, basically, you help someone unload a truck that's stolen goods. You know they stole them. You're guilty, because you want to help the person who did it. It had nothing to do with any kind of proceeding about justice, obstruction of justice. That's all Virginia requires. We look at elements, and jury instructions are tailored based on the evidence presented in the case. I guess it's a broad range, but whatever it is, but it sweeps clearly broad. It doesn't require any specific intent to obstruct justice at all. It's just to, as you said, Dalton, you're right on it, exactly. That, the crime is committed, is completed, and it's been done, and you're trying to help the person who did it. That's all. Either way, I agree with you. Either way you look at it, whether you say it's ambiguous, you still come to the point you can't get past that approach. And what about, not to mention the rule of lenity. I mean, in terms of you have to, dual standards, you default to the criminal statute. But anyway, interpretation, but you didn't get to that, but that's fine. Unless you have anything further, we can move on.
I agree, Your Honor. Thank you.
All right. Miss Kiffin, I'm sorry.
Okay.
Good morning. May it please the court, my name is Margot Niffin for the United States Attorney General. Your Honors, the court should deny this petition for review. Not only is the board's definition of offense relating to obstruction of justice entitled Chevron deference, but the board correctly concluded that the petitioner's accessory after the fact offense constitutes an aggravated felony under this provision. To begin, the court should afford Chevron deference to the board's reasonable definition of offense relating to obstruction of justice. As the majority of the courts who have considered this issue have concluded, the phrase offense relating to obstruction of justice is ambiguous. Now, when considering this analysis, the court should apply the framework that the Supreme Court set out in Esquivel-Quintana. There, the Supreme Court said that unless a phrase is expressly defined by statute, the court should consider a number of different sources, to determine a phrase's ambiguity, including federal and state statutes and the Model Penal Code. Here, the phrase offense relating to obstruction of justice is not specifically defined in the INA. And critically, it is not defined by cross-reference to Chapter 73. This is important because in Esquivel-Quintana, the Supreme Court indicated that if there is not such a cross-reference, the court should not look to the federal statute to determine a phrase's ambiguity. Nor do the dictionary definitions of obstruction of justice provide a clear and unambiguous definition at the time of enactment. Specifically, the Dictionary of Modern Usage defined obstruction of justice as a broad phrase that captures every willful act of intimidation, force, or corruption that lends itself to somehow impair the machinery of justice. Now, this is anything but clear and unambiguous.
Counsel, may I ask a question? Why should this court defer to Chevron deference to an administration, executive branch agency in terms of interpreting what a criminal statute means?
Well, as this court has even recently concluded in Del Maya, Congress has specifically provided the Attorney General with deference in interpreting the phrases of the INA. And this deference is particularly important in the context of immigration. And this court has over multiple times indicated that Chevron deference is the appropriate framework when considering—
Can you cite the case where we have to, would you please cite the case where we have to defer to their Chevron deference for deciding what a criminal statute means?
For instance, in Espinal Andrades, which was another aggravated felony provision. I believe it was 1101-843E. In that case, the court indicated that Chevron is the appropriate framework, and to the extent that the rule—
Can you tell me what phrase in the criminal statute, the criminal offense was being in question?
That was arson, I believe. And
so we had to defer to them as to what arson means?
In that case, the court indicated that Chevron was the appropriate framework, and that because the phrase in the INA was ambiguous, it did defer under Chevron's second step to the board's definition. And in addition, it considered the rule of lenity, and it indicated that the rule of lenity only plays a role if there is a grievous ambiguity when considering phrases of the INA. And here too, I think it's important that obstruction of justice in 1101-843S it's not obstruction of justice alone. It's a broader phrase, offense relating to obstruction of justice. And so I think that's why—
Counsel, can I also ask, I find this is an interesting point. So I want to make sure I understand. One, I take your point to being we've just done it. But if we get to sort of why we've done it in 5 or 6 cases doing aggravated felons. Is it because the criminal application here is only indirect? So in other words, you don't get prosecuted for having committed an aggravated felon. It only affects your sentence if you've previously been deported as an aggravated felon, right? And so it's the civil action that has an indirect effect on the criminal action, not a direct effect. If it was a direct effect, then we might be in the Leocal context. But whereas indirect in the aggravated felon context, we do not ignore Chevron. We instead apply it. Is that a fair summary of what we're looking at?
That is correct. And I think that's what distinguishes this case from Leocal and Karachuri, in that those cases, the Supreme Court was specifically looking at a criminal statute. Here, there is no cross-reference to a criminal statute. Instead, we're looking at a phrase in the INA, and so we're looking at it in the civil context of the immigration context. And that's why, as this court has repeatedly indicated, Chevron is the appropriate framework to consider here.
So let's assume that Judge Richardson, which you've adopted his argument, if you take that argument, do you still have to look at categorical match?
Yes. Yes. So
does Virginia sweep more broadly? Do we have to look at lenity there?
So when we're looking at, so the rule of lenity, as the petitioner proposes, would be relevant in considering whether to defer to the board's generic definition. So as we argue, the rule of lenity doesn't apply. And so we're looking first to see whether the phrase is ambiguous, which it is. And then because it's ambiguous, the court must defer unless the board's generic definition is arbitrary, which it clearly is not. So that's the first consideration.
How broad does it sweep? Does it include someone who helps their friend who stole some property from a burglarized home unload the truck? Does it sweep that broadly?
So the board, in constructing, again, we're looking to see whether the board's analysis in constructing this definition is reasonable. The board reasonably considered both Chapter 73 and the offenses encompassed under Chapter 73 and 18 U.S. 3 in determining what the generic offense encompassed.
I understand the argument. You've adopted that Judge Richardson's argument about why you do that. I understand it. But are you saying now you don't have to look at whether or not it's a categorical mark, follow our precedent in the Fourth Circuit and follow that? You don't have to do that either?
No, so now we look, once we determine the generic offense, we do the categorical approach and we compare the Virginia statute to that. Here, in looking at Virginia's accessory after the fact, I think it's first important to emphasize that the petitioner failed to exhaust any challenge regarding the reasonable foreseeable proceeding. The only issue before the court is whether Virginia's accessory after the fact is overbroad when compared to, as to the extent requirement, is overbroad when compared to the generic.
Okay, I follow that. Go ahead. I'm saying, go ahead now, let's do your categorical analysis.
Okay, so under the categorical analysis, we're looking to the issue of specific intent. Virginia case law dating back to 1875 in Wren has indicated that there is a specific intent requirement.
Counsel, along that line, as I understood opposing counsel's argument, which would be part, I take it, of the question you're now addressing. As I understood that argument, she indicated that the government's position takes obstruction of justice beyond the definition in the Wren case, that it's broader than that. So if you could address that argument as well.
Of course. And so to the extent that she's challenging the reasonable foreseeable issue, as I indicated, that is not exhausted. So we're specifically looking at the specific intent requirement that the board has required under its generic offense. In Wren, the Virginia Supreme Court indicated that a defendant must act with the view of assisting the principal to evade punishment. And that requirement has never been overruled by the Virginia Supreme Court. It was repeated again in Buck about 30 years later. And as discussed, it currently appears in the model jury instructions, as well as in Eastern District of Virginia, federal case from 2017, and Virginia Court of Appeals cases. And so that specific intent requirement has always been a part of Virginia state law.
Virginia, that Virginia case of accessory after the fact that only requires knowledge, not in a specific intent to assist with evading justice. It's just that you knowledge that the person, we have to go by elements. And what Virginia, are you saying Virginia you would not be guilty if you were helping your friend who burglarized the home unload the truck to get into his home or to wherever? You're saying that under Virginia, that would not be prosecuted under that statute? Are that you represent to the court?
So if we look at the facts of Wren, I think that's.
No, I didn't. Did you hear my question?
Under Virginia law, if you provided that assistance with the intent of helping the principal evade punishment,
That's the point. It does not require a specific intent to invade justice. It only requires you to aid the person who committed the crime. That is, he couldn't lift everything himself, so you helped him lift it, and you knew he stole it. That's all that's required.
Under the jury instructions, there is a specific intent requirement.
Jury instructions aren't elements.
They are a requirement of the offense. And I think that, again, looking at
No. Every jury instruction doesn't go to an element necessarily. There's jury instructions talk about what does reasonable doubt mean, what is proximate cause. There's all kinds of jury instructions. I'm sure you know, you've tried a case before. And so we're talking about elements here when we do that. You have to follow Fourth Circuit precedent. I mean, we got a lot of case law that talks about these matches. And we look for whether or not it is a match. And certainly Virginia, and we look at what they convict people of. And they certainly convict people of accessory after the fact. You know, I'm a Virginia lawyer, and Judge Agee is even more so, not only a lawyer, but a former justice. I know, well, you know, I had to say, oh, wait a minute, you moved that truck, but my affirmative defense is I didn't try to obstruct justice. I don't care. Didn't you know they stole it? Yes. Did you help them? Yes. And if it was a finished crime, yes. You're guilty.
Well, I think under the petitioner has pointed to no cases that show that someone was convicted for this offense, for accessory after the fact, with any broader intent than, and I think that's, again, under Wren, the Supreme Court said that the defendant was not guilty because although he provided assistance to the principal in that case, he did not arrest the principal right away, and then he helped with bail. And the Virginia Supreme Court said that this wasn't enough because although he provided that assistance, his intent was not to do that in order to help the principal evade punishment. His intent was to get the money back for the victim in that case. And the Virginia Supreme Court said that he was not guilty of accessory after the fact. And that case, Wren, has consistently been cited since that time as the seminal accessory after the fact case in Virginia.
Counsel, I just don't have it in front of me. But back to the Chief's question on the model instructions. Do the model instructions describe specific intent as an element of the offense or not? I just don't have them here.
They, I can read it specifically so as not to. So under the instructions, under the fourth element, the fourth requirement, it says that the defendant comforted, relieved, hindered, or in any other way assisted the person who committed the crime with the intent of helping that person escape or delay capture, prosecution, or punishment. So it is a part of the fourth instruction that they provide assistance with the intent of helping the principal escape or delay or capture prosecution.
But the beginning paragraph to that, I think, is the answer to Judge Regerson's question. The Commonwealth must prove beyond a reasonable doubt each of the following elements. And it lists specific intent as a element of the crime in the jury instruction. Is that correct?
That is correct. Thank you. Yeah. And this is also, we see as instructive, again, in Schmidt, a recent federal district court decision, the federal district court did read in an intent requirement. In that case, the district court indicated that because the person, when they provided assistance, thought that it was they didn't believe it was the principal in that case, they thought it was someone else, there wasn't the intent that was necessary to have been guilty for accessory after the fact. So in addition to the jury instructions, we see, and the Virginia Court of Appeals as well, we see these other sources also referencing this specific intent requirement.
And those things that the Judge Agee read, do you read them to be in the conjunctive or in the disjunctive? You have to do all of those things, or one of them could satisfy specific intent?
Each of the following elements of that crime. So each of the following must be proved.
So everything in the list is in the conjunctive, right? So in Virginia, you have to prove specifically that beyond knowing that was stolen, you wanted to make sure the person wasn't captured. How do you prove that?
Yes.
How would you prove that?
I mean, I think that there could be a number of different, if it can be proven that someone acted with an intent other than to help the principal evade punishment. For instance, in Wren, there was evidence that the principal, or the defendant was just trying to do his job as a detective, that the victim in that case actually didn't want the principal to be put in jail at that time. He just wanted his money back. And the Virginia Supreme Court indicated that because there was this evidence of another intent, that the defendant wasn't guilty of accessory after the fact. So I think that's a good example. Or in Schmidt, there was not evidence of a specific intent because the defendant thought that he was helping someone else. And so again, if there's evidence that someone acted for an intent other than to help the principal evade justice, they wouldn't be guilty under Virginia state law.
And you read this in light of Fourth Circuit precedent, how this analysis is done.
Yes, under Fourth Circuit precedent, in looking at how we applying Chevron, the phrase offensive relating to obstruction of justice is ambiguous. The board's definition is not arbitrary or capricious. And then looking to the categorical approach, the only issue before us is that of specific intent. And based on Virginia Supreme Court law, there is a categorical match. The petitioner has not established that it is overbroad as to the specific intent issue. And so if there are no further questions, in conclusion, the court should afford, the board's reasonable definition of offense relating to obstruction of justice is entitled to Chevron deference. And in that the board correctly concluded that the petitioner's offense is a categorical match to that definition, the court should deny this petition for review. Thank you.
Thank you. Ms. Giffen. Ms. Hutton, you have some time left.
Thank you, Your Honor. I want to try to reach a point about the state offense and a point about the federal offense. So on the state offense, I to comment briefly that the government's analysis here is completely wrong, that somehow if retrospectively I could prove that a different intent had been required by a court, it is some sort of is a strange analysis for a criminal for criminal liability, that the defendant has to prove a different intent somehow. But if we're going to take that retrospective guessing exercise, certainly cases like I believe the Johnson case that Your Honor has been referencing about loading goods, the Dunn case where the accessory used cocaine that was bought with the proceeds of a crime, the Goodson case where the accessory was an accessory to a first robbery and then went along and participated as a principal in the second. All of those easily give rise, if we're going to guess in retrospect about what an accessory might have been intending there. It was not an intent towards an existing investigation or proceeding. But the most important thing about
is your position on that, counsel, that those cases overrule Wren and Buck?
No, Your Honor. Wren and Buck serve to describe the act and are harmonized by the Supreme Court in Dalton. And what those cases show is that there's no limitation being placed on present day prosecutions or reasonably contemporary prosecutions based on the intent. These are sufficiency of the evidence challenges where there's no reference to the intent whatsoever. And so it's assumed that without intent,
do you know in the Johnson case, for example, do you know what the jury instructions were in Johnson?
I do not, Your Honor.
And in any of those other cases?
No, Your Honor. They span a decent span of time and complex prosecution, often multi-defendant cases. It's a little harder to figure out.
So what we know is that the appellate court decisions don't discuss specific intent. We don't know what the jury in those cases was required to prove, whether they complied with the court's admonishment in Wren and Buck, or whether they followed the model jury instructions. one way or the other based on those decisions.
We don't know, and so it's determinative that the courts are not applying any specific intent limitation or filter, which is very germane here because we're looking to see, does the intent go more broadly than the federal offense. So just I wanted to respond to a question, Judge Richardson, that you raised in my opening argument about section 1510, which I did get to glance at, and it refreshed me that it's an investigations proceeding. And so I think it's got to be important that even under Espinoza-Gonzalez and under the position that we're advancing here, that existing investigations certainly are included in that generic definition of the federal offense relating to obstruction of justice.
No, but 1510 is not about an investigation, right? It's to prevent communication of information relating to the violation of a criminal statute, right? So that exists like before there is an investigation. That's the point. This is an initial one. There's a different statute for healthcare. There's a different statute for bankruptcy, right? The point of that is that that's no suggestion that requires an investigation to pre-exist the crime.
Your Honor, I apologize then. Must have been reading very quickly, but the point of those provisions then is they would still satisfy a really meaty test for foreseeability where you'd be proving an intent for the specific proceeding. It's preventing reporting for a specific proceeding that's going to have that nexus that's been upheld since 1893, and it's going to have a subjective intent and a particularity element. And really the common problem with the government's arguments on both the state offense and the generic offense is that they want to write the object out of the grammar here. There does need to be particularity. You have to interfere with something. In 1893, the Supreme Court said, obstruction of justice requires something to obstruct. In 2018, in Marinello, it says, obstruct suggests an object. And so what all of these Chapter 73 offenses have in common,
why couldn't an object be a future investigation? Right? I mean, that's the object. You have to have an object, but the object need not be in existence at the time. It needs to be a future investigation. If I obstruct a future investigation would be the object in that sentence.
Your Honor, if the future investigation is reasonably foreseeable to the defendant, is particular and has a nexus with their activities for the few provisions of Chapter 73 that would apply to, then yes, that's what the Supreme Court has said. But it would not be just an intent to frustrate law enforcement. That would be unconstitutionally vague. It would violate due process. It would not be administrable. And there would be a massive separation of powers issue.
Whether it's before or after an investigation, it has to be if the object is to frustrate the investigation. That's the point.
Right.
That's the tethering point to it. And the mere fact that just because it could be before doesn't untether it from that. It's beyond, it's amazing that the rule of lenity doesn't exist anymore. It doesn't seem like. And on one hand, we say the Supreme Court's case doesn't, but in the Virginia Supreme Court, which obviously Virginia is not following because it's certainly convicting people without any specific proof of anything about an investigation at all. I mean, that's just a fact. But anyway, do you have anything else, counsel?
Your Honor, can I respond to that last point very briefly, which is just that if there is a question of what Virginia is actually doing, what Mr. Puget needs to show, and we think we've really surpassed this standard, but it's just a reasonable probability that it would have, prosecution could have been sustained in that overbroad form. So these past cases are relevant, and whatever the jury instruction is today, or whether you think that there is no need to cast judgment on what the actual law necessarily is today to meet that reasonable probability standard, and we think we've done that. So for all of those reasons, we ask that the court grant Mr. Puget's petition and vacate his order of removal.
Thank you so much. Ms. Hutton, we note that you're a court opponent and take this assignment. Thank you so much. We appreciate on behalf of the Fourth Circuit. We couldn't do our jobs without counsel like yourselves who take these on. And also, Ms. Niffen, we thank you for ably representing the Attorney General in this matter. Counsel, we can't come down and shake your hand, but know that we appreciate your arguments. Thank you for being here. We hope that you and pray will continue to be safe and well. Thank you. And with that, I'll ask the clerk to adjourn the court, I guess, until 2 o'clock this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.